Hello, I'm David Roger, General Counsel for Las Vegas Police Protective Association. Recently, we produced a video dealing with whether an officer may go to a person's house to make a probable cause arrest, an arrest without an arrest warrant in violation of the Payton Rule. We discussed the Payton Rule. And the question became, can you still do a knock and talk? Even though you're going to a person's residence. And what we said in that video is don't use a knock and talk as a ruse to be able to get a person to come out so you can arrest them for the DV warrant. So this video is going to talk about the knock and talk. In 2011, the U.S. Supreme Court addressed the knock and talk exception for the first time. And it is Kentucky versus King. And this is what the U.S. Supreme Court had to say about the knock and talk. When law enforcement officers who are not armed with a warrant knock on a door, they do no more than any private citizen might do. And whether the person who knocks on the door and requests the opportunity to speak is a police officer or a private citizen, the occupant has no obligation to open the door or to speak. When the police knock on a door, but the occupants choose not to respond or to speak, the investigation will have reached a conspicuously low point, and the occupants will have the kind of warning that even the most elaborate security system cannot provide. And even if an occupant chooses to open the door and speak with officers, the occupant need not allow the officers to enter the premises and may refuse to answer any questions at any time. And so what the U.S. Supreme Court is saying in that case is that, people can consent to talking to you out on the street, not necessarily at their home, but people can consent all the time, and it doesn't necessarily make it a Fourth Amendment issue. So you approach someone on the street and you say, hey, can I talk to you? And they go, no, pound sand. Well, they can walk away, and you have to walk away as well unless you have reasonable suspicion to detain them. And it is not a Fourth Amendment violation. And the same thing with a knock and talk. If someone chooses to answer their door and talk to you, it's consensual. It's not a Fourth Amendment detention or arrest. And so 2 years later, in a case called Florida versus Jardines, Jardines, a 2013 case, the U.S. Supreme Court expanded on their decision and explained a little bit further by why they do not believe, or it's their opinion, that a knock and talk is consensual and is not a Fourth Amendment issue. And they talked about an implied license. And, I'm going to paraphrase, and then we'll talk about the specific language of the decision. But when a person has, they said a knocker on a door. Nobody has a knocker anymore, but you have a house, you don't have a locked gate, you have it open, or you have an apartment, you are inviting people to come up and knock on their door. Kind of like Girl Scouts selling cookies or some other vendor. And so the idea is that it is an implied license. The owner of the residence, or the people who are occupying the residence, are inviting people to come up and knock on the door. And if they don't want to answer, they don't answer. If they want to answer the door and they go, I'm busy, I don't want to talk, they can close the door. And so it is a license, but it is their license to give. And so the U.S. Supreme Court talks about an implied license, which means, the person on the other side of the door, the visitor, doesn't know whether the person is home, doesn't know whether the person wants to talk to him, but there is an implied license, there is an implied invitation to come up and knock on the door. And so this is what the U.S. Supreme Court said, and it's a little archaic language, but you'll get the point. A license may be implied from the habits of the country, notwithstanding the strict rule of English common law as to entry upon a close. We have accordingly recognized the knocker on the front door is treated as an invitation or license to attempt an entry, justifying ingress to the home by solicitors, hawkers, peddlers of all kinds. That's archaic language. This implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave. Complying with the terms of this traditional invitation does not require fine-grained legal knowledge. It is generally managed without incident by the nation's Girl Scouts and trick-or-treaters. Thus, a police officer not armed with a warrant may approach a home and knock precisely because that is no more than any private citizen might do. And so that is the U.S. Supreme Court explaining knock and talk. It is an invitation to anybody, including police officers, to come up and knock on the door, and if the occupants want to answer the door, they can. If they don't, they don't. And so that is the knock and talk. It is not a Fourth Amendment issue. It's more akin to consent. There you go. There is the U.S. Supreme Court decision. And now I want to talk about the Ninth Circuit. But before I do that, I want to talk to you generally about legal principles. And so the U.S. Supreme Court will decide issues of federal constitutional law. And, you know, they can't predict every factual scenario that might occur. And so they give the court's general principles. And this is the general principle, right? Police can go up to a person's house and knock on the door, and if the person wants to answer, so be it. But it's not a Fourth Amendment issue. And then from there, the courts, the Ninth Circuit Court of Appeals, which is the federal appellate court that we have to deal with, and then the state courts can apply the same decisions and interpret their own state constitutional. But until we get a factual scenario that makes it all the way up to the U.S. Supreme Court, we're stuck with these lower court decisions. Thus, in the Ninth Circuit, which is one of the most liberal circuits, the Ninth Circuit decided a case interpreting Florida versus Jardines and the Kentucky case. And their interpretation is binding on us until the U.S. Supreme Court tells them that they are wrong. And the Ninth Circuit Court of Appeals talked about a case in which police went and did a knock and talk at 4 o'clock in the morning. And the Ninth Circuit Court of Appeals said that that was unreasonable, that the implied license, the license that the occupants are deemed to have given people, is for officers to, or people to come to their house during daytime or regular hours. And, you know, nobody can say what the regular hours are. You know, I go to bed at 10 o'clock at night. So if someone came to my door at 11 o'clock at night, would that be a license to come knock on my door? Probably not. But there are other circumstances where maybe officers know that the person is a swing shift craps dealer at the Aria, and they get home at 2 o'clock in the morning, and, you know, they're not in bed. You know, maybe that would be considered an appropriate knock and talk at 2 o'clock in the morning. But as you can see, facts vary and scenarios vary. But the Ninth Circuit Court of Appeals, you know, said that under their circumstances where there's no indication that the person was normally up at 4 o'clock in the morning, it was an unconstitutional knock and talk because the officers had no reason to believe that a person would invite people to come to their home at 4 o'clock in the morning. And so you can see that, you know, these general principles of case law that we talk about in videos are basically that. And so at least with respect to the federal constitutional law in the Ninth Circuit, you can do a knock and talk, but it has to be during regular hours, whatever that may be. And ultimately, the federal courts will decide. For your purposes, I try to give you bright line rules. The the takeaway from this is that knock and talks are still available to you as a resource to investigate crimes, but don't only do so during normal hours. If you're working graveyard and you want to go do a knock and talk at 3 o'clock in the morning, it's probably going to be deemed to be unconstitutional. Finally, a final issue is this. There's been a lot of discussion about the last video and, whether you can still arrest someone on a DV 7 days later or whatever the statute says. And of course you can, but you can't go up to their house. You can't go up to their apartment. There are a lot of ways to arrest someone where you're not arresting them at their residence without a warrant. You can go to their workplace. You can do surveillance if it's important to get that person into custody and do a vehicle stop. So there are a lot of ways around it. I'm not suggesting that you not arrest people for domestic violence based upon probable cause. What I am saying is don't go to their house without an arrest warrant. As always, thank you for what you do. I appreciate you watching these videos. Please subscribe so that you get these videos in a timely fashion. And if you want to go back, we have an entire library on the YouTube channel of videos concerning other legal issues. Thank you very much. And as always, contact me at droger@lvppa.com if you have questions.
111, 110.